This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. So Maria Rutenburg's lawsuit against Twitter has finally been dismissed, and we're going to look at this and we're going to see why, but it's only a couple pages long, and it does cite to a few other cases, including the Knight First Amendment Institute case. And of course, now the Knight First Amendment Institute case has been heard or evaluated by the Supreme Court of the United States and then denied as moot, since that involved former President Donald Trump, who is now former president and is now been banned from Twitter. And so that case no longer is a live case or controversy. I have some feelings on that, but we'll get to that later. And there's also another cited case, Lugar versus Edmondson Oil Company, that's involved with the Maria Rutenburg case. And we're going to read the syllabus of that. So get your popcorn and listen up. This is in the United States District Court for the Northern District of California. This is Maria Rutenburg v. Twitter, order dismissing the case for lack of subject matter jurisdiction. We'll go over the jurisdictional issue in a moment. Plaintiff Maria Rutenburg brings this action against defendant Twitter based on Twitter's decisions to 1. Delete, remove, or apply warning labels to certain tweets regarding dishonest claims of election fraud from former President Donald Trump's account, and 2. To suspend and thereafter permanently remove Trump's Twitter account from the Twitter platform. Rutenburg commenced this lawsuit on January 22nd, 2021, 2 days after current United States President Joseph R. Biden assumed office. As alleged in the complaint and reflected in the record, Twitter took these actions in response to Trump's promotion of a stolen election, as well as the inflammatory tweets to the now infamous insurrection at the United States Capitol in January 6, 2021. Based on these actions, Rutenburg brings one cause of action, a violation of Rutenburg's federal constitutional rights under the First and 14th Amendments pursuant to 42 U.S.C. Section 1983, which is a very famous and very large civil rights lawsuit. Now, the First Amendment protects against the federal government's intrusion upon the freedom of speech. The 14th Amendment incorporates that against the states, so that the First Amendment applies to the states through the 14th Amendment. We call that incorporation. The matter is now before the court, the Northern District of California, based on the parties' briefing in response to the court's order to show cause. Specifically, the court requested the parties to brief whether this action should be dismissed, given that Twitter, as a private, non-state actor, cannot be held liable for a 1983 claim. Having reviewed the parties' briefing, the court orders this case be dismissed for lack of subject matter jurisdiction. Rutenburg filed a motion for a temporary restraining order shortly after commencing this action. The court summarily denied this motion. We covered that. I'll put a bubble. Explaining that a fundamental flaw in Rutenburg's entire case is that the claimed rights under the First Amendment and the corollary claims under the 14th Amendment cannot be enforced against a private entity, such as defendant Twitter. See Manhattan Community Access Corporation v. Halleck. The text and original meaning of those amendments, as well as this court's long-standing precedents, established that the Free Speech Clause prohibits only governmental abridgment of speech. The Free Speech Clause does not prohibit private abridgment of speech. See Belgao versus Inslee. The Supreme Court has long held that merely private conduct, however discriminatory or wrongful, falls outside the purview of the 14th Amendment. See Roberts versus AT&T Mobility. A threshold requirement of any constitutional claim is the presence of state action. Because the First Amendment right to petition is a guarantee only against abridgment by the government, state action is a necessary threshold which a plaintiff must cross before we can even consider whether a defendant infringed upon a plaintiff's First Amendment rights. See Flag Brothers v. Brooks. While as a factual matter, any person with sufficient physical power may deprive a person of his property, only a state or a private person whose action may be fairly treated as that of the state itself may deprive him of an interest encompassed within the 14th Amendment's protection. Following this denial, the court issued the instant order to show cause. A complaint can be dismissed for lack of subject matter jurisdiction if its federal claim is so insubstantial, implausible, foreclosed by prior decisions of this court, or otherwise completely devoid of merit as to not involve a federal controversy. This is basically saying that if you don't have a claim, then the court can't have jurisdiction over this non-claim. In other words, she's not being denied because the court has had a hearing and heard all the evidence and everything. The court is saying that the claim is so light, is so unsubstantiated on its face at the very beginning of the case, that there is no jurisdiction even for the court to recognize the claim. A court may act on its own initiative to dismiss such an inadequate complaint. See Lampros v. Baker, upholding on its own a dismissal of a Section 1983 claim because the plaintiffs had failed to allege state action. Here, in response to the order to show cause, Rutenburg asserts that Twitter's conduct constitutes state action. This is crucial for Rutenburg to allege because Section 1983 provides a remedy for the deprivation of federal rights, but only when that deprivation is caused by conduct that is fairly attributable to the state, and therefore undertaken under color of state or federal law. See Lugar versus Edmondson Oil Company. Lugar versus Edmondson Oil Company is a 1982 Supreme Court case, and we're going to read the syllabus here. This case concerns the relationship between the requirement of state action to establish a violation of the 14th Amendment and the requirement of action under color of state law to establish a right to recover under 42 U.S.C. 1983, which provides a remedy for deprivation of constitutional rights when that deprivation takes place under color of any statute, ordinance, regulation, custom, or usage of a state. Respondents filed suit in Virginia State Court on a debt owed by petitioner and sought prejudgment attachment of certain of petitioner's property. Pursuant to Virginia law, respondents alleged in an ex parte petition, without the other party, a belief that petitioner was disposing of or might dispose of his property in order to defeat his creditors. Acting upon that petition, a clerk of the state court issued a writ of attachment, which was executed by the county sheriff. A hearing on the propriety of the attachment was later conducted, and 34 days after the levy, the trial judge dismissed the attachment for respondents' failure to establish the alleged statutory grounds for attachment. Petitioner then brought this action in federal district court under 1983, alleging that in attaching his property, respondents had acted jointly with the state to deprive him of his property without due process of law. The district court held that the alleged actions of the respondents did not constitute state action as required by the 14th Amendment, and that the complaint therefore did not state a valid claim under Section 1983. The Court of Appeals affirmed, but on the basis that the complaint failed to allege conduct under color of state law for purposes of Section 1983, because there was neither usurpation or corruption of official power by a private litigant, nor a surrender of judicial power to the private litigant in such a way that the independence of the enforcing officer was comprised to a significant degree. The holding from the Supreme Court said, 1. Constitutional requirements of due process do apply to garnishment and prejudgment attachment procedures whenever state officers act jointly with a private creditor in securing the property in a dispute. And if the challenged conduct of the creditor constitutes state action as delimited by this court's prior decisions, then that conduct is also action under color of state law and will support a suit under Section 1983. 2. Conduct allegedly causing the deprivation of a constitutional right protected against infringement by a state must be fairly attributable to the state. In determining the question of fair attribution, A, the deprivation must be caused by the exercise of some right or privilege created by the state, or by a rule of conduct imposed by it, or by a person for whom it is responsible. And B, the party charged with the deprivation must be a person who may be fairly said to be a state actor, either because he is a state official or because he has acted together with or has obtained significant aid from state officials, or because his conduct is otherwise chargeable to the state. 3. Insofar as petitioner alleged only misuse or abuse by respondents of Virginia law, he did not state a cause of action under 1983, but challenged only private action. Such challenged conduct could not be ascribed to any governmental decision, nor did respondents have the authority of state officials to put the weight of the state behind their private decision. However, insofar as petitioner's complaint challenged the state statute as being procedurally defective under the Due Process Clause, he did present a valid cause of action under Section 1983. The statutory scheme obviously is the product of state action and a private party's joint participation with state officials in the seizure of disputed property is sufficient to characterize that party as a state actor for purposes of the 14th Amendment. Respondents were therefore acting under color of state law in participating in the deprivation of petitioner's property. So, returning with that new knowledge back to Rutenburg, despite her arguments to the contrary, Rutenburg's arguments, Twitter is not, in fact, a state actor for purposes of Section 1983, and therefore cannot be held liable for an alleged deprivation of a federal right. As Twitter correctly explains, Lugar sets forth two requirements to determine when conduct is attributable to the state. The first requirement concerns the exercise of state authority. In connection with a violation of the plaintiff's federal constitutional rights, a defendant must have exercised some right or privilege created by the state. Meanwhile, the second requirement, often described as the state actor requirement, asks whether the defendant is a person who may fairly be said to be a state actor. Here, Rutenburg's allegation does not and cannot satisfy these two requirements. First, Rutenburg makes no allegation that Twitter exercised any state right or privilege to restrict her access to former President Trump's tweets. Lugar instructs that the alleged deprivation of constitutional rights must be rooted in the exercise of a state's sovereign power. See Florer v. Congregation Pidion Chevium, analyzing a Section 1983 claim in terms of whether the deprivation was caused by the exercise of a right or privilege created by the state. Instead, Rutenburg points to a supposed delegation of authority from former President Trump to operate what she contends is a public forum. At best, the amended complaint merely describes how Twitter, using its own technical means, reportedly disabled, removed, or otherwise restricted former President Trump's tweets and accounts. None of this has any connection with the exercise of authority by a sovereign state. Thus, the amended complaint fails to allege any conduct with a nexus to a state privilege or power. Second, Rutenburg's allegations do not demonstrate that Twitter is an entity that may be fairly said to be a state actor. It is undisputed that Twitter is a private company. See docket number 2, paragraph 14. Twitter is an ubiquitous social media company. See docket number 17. Twitter is a private company. Federal courts have uniformly rejected attempts to treat similar social media companies as state actors under Section 1983. See Prager University v. Google, which we've covered. I'll put a bubble. A Ninth Circuit 2020 case concluding that YouTube did not perform a public function simply by hosting speech on a private digital video platform for the public. See Howard v. AOL, a Ninth Circuit 2000 case finding no subject matter jurisdiction for a Section 1983 claim because AOL was not a state actor, even if it allegedly acted as a quasi-public utility that involves a public trust. See Abed versus Facebook, a Northern District of California 2019 case, rejecting the argument that Facebook was a state actor because it allegedly regulated speech in a public forum. See Nyabwa versus Facebook, a Southern District of Texas 2018 case, finding that the plaintiff had failed to state a First Amendment claim because Facebook was not the government. See Schulman v. Facebook, a District of New Jersey 2017 case, rejecting the plaintiff's constitutional claims against Facebook because Facebook was not a state actor. See Kinderstart.com v. Google, a Northern District of California 2007 case, rejecting arguments that Google was a state actor for constitutional claims. See Langdon v. Google, a Delaware 2007 case, ruling that Google is a private entity not subject to the plaintiff's constitutional claims. And see Cyber Promotions versus America Online, an Eastern District of Pennsylvania 1996 case, concluding that AOL does not stand in the shoes of the state. Furthermore, as the United States Supreme Court recently recognized, merely hosting speech by others is not a traditional exclusive public function and does not alone transform private entities into state actors subject to First Amendment constraints, from the Halleck case from 2019. Simply put, Rutenburg cannot transform Twitter into a state actor based on an allegation that the company administered former President Trump's account, which is all that is alleged in the amended complaint. In sum, Rutenburg has failed to demonstrate that Twitter is a state actor sufficient to trigger liability for an alleged deprivation of federal rights under Section 1983. Rutenburg conflates decisions finding that former President Trump's usage of Twitter is a public forum, conflating the former president's ability to summarily block critics, and impermissibly attempts to extend this underlying logic to Twitter. This fails where Twitter is not a state actor and is not exercising any sovereign state authority. Rutenburg's citations do not persuade where such cases concern state actors, including elected state or local officials. Rutenburg otherwise fails to cite to a single case where a court has found a private non-state actor liable under 1983 for alleged violations of constitutional rights in similar circumstances. Accordingly, the court dismisses this action for lack of subject matter jurisdiction. The clerk is directed to close this case. It is so ordered. Yvonne Gonzalez Rogers, United States District Judge for the Northern District of California. And that is the correct decision. I don't have any problem with this decision. We have a plethora of case law. We have myriad cases showing how you must be a state actor in order to be subject to laws that provide remedies against improper state action. The fact that people can go to a town square and step on a soapbox and start preaching whatever they want to preach does not mean they are acting on behalf of the state. The fact that a private entity like a hair salon or a bar or a website allows private people to sign up for an account or attend the physical location. The fact that a stadium or a conference center or a hotel allows someone to get up on a stage and speak does not make the hotel or the conference center or the stadium the actor that is allowing that speech. It makes them the host of the conference or the host of that speech, but it does not mean that when they deny someone that speech, that they are acting on behalf of the government. If I go and apply to Marriott for a conference room and they say, we're sorry, we don't want to host your event, that does not make them a government actor. If I go to Twitter and I apply for an account, or I already have an account and my account gets banned, maybe I have a claim based on some violation of the terms of service. You probably don't, but that would be the basis for a violation. But if they deny my account or if they ban me within the terms of service, that does not make Twitter a state actor. You would need something more. You would need an actual state actor. You would need some sort of direct permission from the federal government to be doing something using government power. The state action doctrine requires either that the state itself is doing something or that someone acting on behalf of the state is doing something. I'll give you an example. I recently moved to Luxembourg. I now have health insurance or health coverage through Luxembourg, and I no longer need my United States health coverage. And so I canceled my health coverage with the United States in Pennsylvania. Well, Pennsylvania recently set up a company called Pennie, Pennie, and Pennie signed me up for healthcare coverage with my old health insurance company. And so I got charged. They actually took the money from my account and signed me up for healthcare coverage, even though I had canceled. I probably have some kind of claim against Pennie under the state action doctrine, under 42 USC 1983, or some other claim, Even though Penny is a private company, they are acting on behalf of the state with the permission of the state to be the healthcare coverage website for the entire state that manages everybody's healthcare coverage, kind of like healthcare.gov, but for the state of Pennsylvania. The actual insurance company is not a state actor, but this middleman, this penny.gov or penny whatever.state.pa.us website, that's more likely to be the state actor. That's what we're talking about. What Rutenburg got confused about, intentionally or not, was the Knight First Amendment Institute case that had said that when the former president operates his Twitter account, that can become state action. That doesn't make all of Twitter a public forum. It's more of a one-way thing because the former president used his Twitter account to make presidential proclamations, not just once, but routinely. Then that became not a public forum, but that became state action. So while Twitter was hosting the president's speech, the president couldn't block people from receiving that speech or responding to that speech. Twitter still had the power to kick him out. This is like if a bar was hosting the president's speech and then the president was saying who could come and who could not. The bar can say who can come and who can not because it's their property, but the president can't say who can come and who cannot. That's the best analogy I can come up with. Now, the Knight First Amendment Institute case was recently struck down by the Supreme Court as moot. So we just go back to the standard state action doctrine without the benefit of the previous precedent of the Knight First Amendment case rulings. And we're going to go over that one next. So we'll release that probably in a day or so, and you can check that out. I'll try to remember to put a bubble here as well, because that's another very interesting case where Justice Clarence Thomas is trying to make the argument in a concurrence that Twitter is a public forum, or under certain circumstances could be. So stay tuned for that case as well. But let me know what you think now of Maria Rutenburg's case via Twitter being denied. Let me know if you think that Twitter should be a public forum, but why should Twitter be considered a government-sponsored public forum? Where is the governmental action? If you believe that Twitter should be held liable under the state action doctrine, what is the government action that enables it? Does that mean that Parler is also a government-sponsored public forum and they need to behave with the same level of deference that Twitter would have to? Should everybody who has a website be considered regulated by the federal government under some sort of designated public forum? And that means that no one is allowed to have a website without it being a designated public forum? Or do we recognize that private entities have control over who's allowed to use their services, kind of like we saw in the Masterpiece Cake case, where the cake maker was allowed to discriminate against who they made cakes for? Let me know what you think in the comments below. So that's our show. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program, here on YouTube, also on Floatplane, and on twitch.tv at Sunday mornings at 10 a.m. Eastern Time. This is a community-supported legal education channel, meaning we need your financial support on a monthly basis on patreon.com/ljfrench, on sponsors.com/law, or through YouTube membership or Floatplane membership. Thank you very much in April of 2021 to our $50 plus supporters: Joe Tyson, John Steele, Gavin Barnard, Eevi, Spirit Bear, Benjamin Hitov, Ugly Grill, Rudolph Bescherer Jr., Torpedan, Brandyn, Abel, Sovereign Tittizen, ShadowTycho, RDHDragon, and Earthbound Star. And thank you very much to the $5 plus supporters. Everyone's been scrolling on the updated LED panel behind me and will be on the videos in front of me that drop. I love you all. Have a great week. I hope you all had a nice holiday weekend, and I will see you in the videos. Bye.
Mum sounded better when she done the gobble gobble.